Thank you again for being here. I want to start by introducing all of us. My name is Cindy Bartz, and I wear a couple of hats that bring me here tonight. I work as a contractor on special projects with Community Entry Services, and I also have a almost 25-year-old son who is a client of CES. Before I introduce the rest of our panelists and our team, I want to make sure that I make clear that none of us is an attorney or a financial advisor. We're here because of our personal experience or professional experience in support of people with disabilities, and we recognize the need to make this information accessible and to hopefully give you somewhat of a head start in putting some of these essential tools in place. So the information we'll be sharing is pretty high level, and we will also provide you in the next day or two with a lot more links where you can pursue some more detailed information on your own and some suggestions about how to take the next steps. So I'm going to let our two panelists introduce themselves. First is Jessie Phillips-Granis with CES.
Hey everybody. Cindy mentioned my name is Jessie Phillips-Granis. Started here at CES about 8 years ago as frontline staff, and I'm now the Jackson Program Director. So really excited about that.
Thanks, Jessie. And Heather, will you give us a quick introduction?
Okay. So I'm Heather Thomas, and I'm a case manager for the Developmental Disabilities Waiver. I've been in this role since 2014, and I serve Teton and Fremont County.
Thank you, Heather. And also helping us tonight is Cindy Castillo, who is over in the Spanish language channel for this meeting, and she is providing interpretation and also has a real heart for the families in this community who are native Spanish speakers and who also have special needs of one kind or the other. And with her camera off, but she's sharing her screen, is Victoria Wade, who is a Jackson local and is involved in the nonprofit community and is providing technical support and is much appreciated. All right, so I wanted to start a little bit by just sharing an agenda, kind of let you know what we're going to be up to tonight. We'll start with some housekeeping, kind of set the stage for who is CES, why have we organized this webinar, give you a high-level overview of what the sources of public support that we're interested in protecting, and then go into some of the tools, which is really the meat of what we wanted to present tonight. We'll end with providing a few resources for legal support and try to leave plenty of time for questions and answers. I'd like to start with a disclaimer that's a little bit more official than what I shared at the beginning, which is that the information we're providing this evening is not a recommendation, referral, or endorsement of any resource and does not replace the advice of legal professionals or financial advisors. CES has not validated and is not responsible for any information or services provided by third parties. I wanted to talk a little bit from kind of a personal point of view for why we are here. Whether we are a person with a disability, whether we are the parent or the guardian or a sibling of a person with a disability, we need to take special care to map out a future for ourselves or our loved one. That includes financial planning and legal arrangements like guardianship and conservatorship. The critical and often lifelong support that's provided to people with disabilities by state and federal programs come with income eligibility criteria, and that can be tricky to stay on top of, especially as our circumstances change or our sources of income change. And as some in our community have found out the hard way, when we don't stay on top of maintaining our income eligibility for these programs, we can lose those benefits and it can be really problematic. So I mentioned I am the parent of a 24-year-old with special needs, and I know firsthand that some aspects of this planning can be overwhelming. We might worry we're going to make a critical mistake in how we put things in place, or we might let years and years go by just avoiding it altogether. I've been there, and I can tell you I have so much peace of mind knowing that for our family, the big pieces are in place. But that being said, there are some pieces of what we're presenting tonight that I haven't done yet. But hopefully together we can all come away from tonight with enough of a beginner's level understanding that we can take whatever are the next best steps given our unique circumstances. So our goal this evening is just to do a high-level overview of some of the basics of special needs trusts, Miller's trusts, ABLE accounts, guardianship, and conservatorship. And those are really the big ones. There are other aspects of planning that you may want to undertake along the way, but in my opinion, those are the biggest and the ones to get started with. Now I'm going to hand it off to Jessie, and she's going to share a little bit more about community entry services. And we are the group that is hosting this webinar tonight.
Yeah, thanks, Cindy. So CES provides a true continuum of comprehensive care, which is designated to meet our clients' needs where they're at and kind of for whatever they need. Different services, but it's essentially broken into 3 pillars, which include adult day hab, community living, and then some financial support. So we'll talk about each of those individually. Our adult day program, located right in town. It's really got a family feel up there. There's a lot going on throughout the day. We're always looking for new and exciting ways to help our clients access their community, as well as gain independence while doing so. We do everything from job coaching to day trips. We have some therapeutic programming. We take our clients to the doctor's office and advocate for them. We also go to coffee shops and, occasional Target shopping hauls. Our community living program is a really good way to kind of bridge that gap between safety and independence. We work closely with the people we serve to help them work on their independence goals and help manage their homes, whether that's in a group home facility, in their own apartment or home. And our staff offers a lot of support in these residential settings, including medication administration, housekeeping reminders, food safety oversight, helping them make healthy choices. And it's a supportive and companion-like presence, allowing for our clients to live as independently as possible, but having that extra support. And then our third, more encompassing, is our financial support, which is pretty crucial to the people we serve, and it varies pretty significantly. We do offer representative payee services where we help navigate the overwhelming world of Social Security. We help our clients manage their benefits and ensure that all their complicated rules are being followed so that their benefits are not in jeopardy. We also help manage stable accounts, which we'll get into a little bit later, but essentially they're investment and savings accounts for people with disabilities, which don't count against their resources. We also help clients in creating and sticking to a budget. We help pay their bills or help them pay their bills. And we make sure they're under their earned income as well as their resource limits at the end of each month. And it's just something, really helpful, especially when it comes to making sure their benefits aren't in jeopardy. We also help manage their pay stubs and reporting those as well. Ultimately, our mission is to empower our clients to maximize their independence and help them lead satisfying, productive lives in our community. So, regardless of which services we provide, that's definitely always at the forefront of what we do here.
Thanks, Jesse. Now, Heather is going to set the stage for us a little bit so that we're all starting from the same set of information and give us a brief overview of the primary support sources of public support that really cover the lifespan for kids all the way up through adults with disabilities.
So the most common sources of support could include cash benefits, health insurance, therapies, long-term care for children and adults with disabilities. So that starts with our early education, development centers, and that could be the school system, and birth from age 21. So Wyoming CDCs provide development screenings and assessments for children under 5. And if eligible for services that may include support in the classroom setting or therapies and care coordination. Federal law dictates that services are based on each student's individualized needs. So a lot of times we see that with the, IEP. And then the Medicaid waiver is our second one. This is the primary programming for providing comprehensive health and long-term care coverage to 1 out of 3 individuals with disabilities. The Medicaid home and community-based waiver, the waiver, as we all know it, provides funds for support services for people who wouldn't normally be income eligible for traditional Medicaid. The waiver is not an entitlement. States often have enrollment caps and waiting lists. As we know in Wyoming, we've been seeing like a 2 to 3 year waiting list, and they have been working on funding the wait list in the last few years. That has been successful, and it's really good to see that. But it's still 2 to 3 years, which is just a crazy for people to have to wait. And then the best website to get information on the Medicaid waiver, we're going to put that at the bottom, but it's the Wyoming Medicaid and Department of Health and Home and Community-Based Services. And like I said, there'll be a link for that. And then funding from Social Security's administration is the third one. Federal government provides income to people with disabilities through 2 programs. There's the Social Security Disability Insurance, which is SSDI. This is for people who have paid into the program through taxes on earned income. And then SSI, which is Supplemental Security Income. This is for people with little or no income or resources. It most likely that your loved one with disabilities will apply for SSI, and you can apply for SSI on behalf of your child at any time. And individuals who are from higher income families who didn't qualify for SSI as a child might qualify once they turn 18. And in Wyoming, if you qualify for SSI, you automatically qualify for Medicaid health coverage. And again, the resource for that adult disabilities starter kit, which includes a list of information you should gather before you start the process. And that can take anywhere from, we've seen 6 months to a year. And I think I would say the least would be 3 months. But Jesse, correct me if I'm wrong. Do you know the time on that once you apply for SSI?
I'm not positive, but that timeline is sounding familiar.
Okay. I don't know that I've ever seen it less than 6 months. Unfortunately, just with all the paperwork and everything, it can take some time. And then SSI and Medicaid waiver have strict resource and income limits for continued eligibility. So this includes what an individual earns from work, money received from other sources such as Social Security benefits, money received from friends and relatives. It also bank accounts, investments, land, vehicles, personal property, life insurance, anything that can be converted to cash and used for food or shelter. This includes gross monthly income less than $1,690 and assets less than $2,000. A home and a vehicle used for work may be excluded up to a certain amount. So there is a cap on that as well, though, for owning a house and a car. The good news and why we're here tonight is there are some tools you can take advantage of to protect these essential public benefits. And these are commonly called protected savings accounts, special need trust, first and third party, pooled trusts, Miller trusts, and ABLE accounts. So there's ways to have more than that, 2,000 in your bank account, or, if making more than 1690, there are ways to protect your money so that you are able to have more money. But like we said, it has to be done in a very specific way, which is, why we're here tonight.
Thank you, Heather. So the first big category that we wanted to cover was the special needs trusts. You might also see them referred to as a supplemental needs trust. And a special needs trust it's a legal entity, kind of like a corporation, a legal arrangement that holds and manages assets for a beneficiary. And in this case, the beneficiary would be the person with a disability. It's for the purpose of maintaining eligibility for public benefits while still having access to the funds that supplement their needs and enhance their quality of life. Special needs trusts allow the person with a disability to have access to those funds without exceeding the asset and income limits and therefore becoming ineligible for the benefit. Funds that are put under the management of a special needs trust can be used to supplement but not supplant government benefits. There are pretty strict rules about what the funds that are in a special needs trust can be spent on. They generally cannot be used for food or shelter or anything that could be used to obtain food or shelter. They are intended to improve the beneficiary's quality of life and to pay for items that are not covered by Medicaid or Medicare. Some of the things we commonly see special needs trusts funding spent on are things like vacation, hobbies, educational expenses. You might also be allowed to include supplemental income, in-home care as one of the expenses that your special needs trust pays for. Things like vitamins, cell phone service, home repairs, and massages. So the details of what is allowed and what is not allowed as expenses are something that you will work on with the attorney that supports you in setting up a special needs trust. There are three main types of special needs trusts: the first party, the third party, and the pooled trust. And we'll go briefly into what the difference is between those three. So first is the pooled trust. This is a type of special needs trust that is authorized and regulated under federal law, administered by a nonprofit organization. In Wyoming, the only organization that is authorized to administer and provide access to a pooled trust is called the Wyoming Guardianship Corporation. And again, we'll have the links to how to get to the details of this information in the resource guide that we'll send out in a couple of days. A pooled trust is irrevocable. That means it's unchangeable once it's established. And a pooled trust will terminate, so it will kind of dissolve upon the death of the beneficiary. In order to qualify to participate in a pooled trust, the person must be considered disabled as defined by Social Security law. One of the important things with two of the types of special needs trusts is that when the beneficiary dies, any money that is left under the care of the trust gets either sent back to the state, in this case, Wyoming, to reimburse the state for the costs of providing services for that person over their lifetime. With the case of a pooled trust, the trust organization, which in our state is the Wyoming Guardianship Corporation, might retain some of those funds for covering their own administrative costs. They might even donate the remaining money to charity. The point is that it's up to the Wyoming Guardianship Corporation to decide what happens to those remaining funds, but they do not go back to the family or anyone else that the designee might have wanted to send those funds to. They are in control of the trust corporation. A pooled trust has some benefits to it that are real specific. The trust document and all of the rules and all of the procedures is already written. So there is no need to hire an attorney to set up or to join a pooled trust, which can be really nice and a huge cost savings. It's important to realize that there are short-term and long-term fees that will be charged by the trust organization. And so when looking at a pooled trust, it's very important to make sure that you understand what all those fees are before you enter into an arrangement with them. A pooled trust generally has a fast setup, which can be beneficial in the case of the beneficiary coming into a large amount of unexpected funds. Maybe they play the lottery. Maybe they bought tickets to a raffle and won the raffle. Maybe they ended up receiving funds in a settlement to a lawsuit. Maybe out of the blue, a relative left money to the beneficiary in their will, and so they have these funds coming to them that would make them ineligible for SSI or the Medicaid waiver. So they can be set up really fast because they already exist. Wyoming only has one administrator of pooled special needs trusts, but there are also a few other options that operate in every state. And the link to that nationwide directory will be on the resources page. They can be a good choice if you are setting up the trust at the age of 65 or older, and then you wouldn't be eligible for some of the other forms of special needs trusts. They can be a good choice if you anticipate that you'll have less than $50,000 in the trust at any given time. Also, if you have a stable situation and don't need a lot of flexibility or customization in how you use your funds in your trust, the trust corporation decides how the funds are spent. So that can be a drawback in terms of, say there's something that you want to spend the funds in your trust on, but that's not allowed by the trust corporation, then you have to work through that with them. So there's less flexibility in how you spend the funds. There's no flexibility in what happens after the beneficiary dies, but they are generally simpler and faster to set up. Another type of special needs trust is a first-party trust. And the first-party trust is different from a third-party trust in that with the first-party special needs trust, this is when the beneficiary has their own assets. Again, they win some prize money, or they receive an inheritance, or they are the beneficiary or of money from a lawsuit. These are their own assets that are already kind of in their name. A first party special needs trust is also irrevocable, therefore unchangeable. And one of the important notes here is that the trust beneficiary needs to be under 65 when the trust is established. They also have to make sure that only their own assets are used to fund the trust. So mom or dad or grandma or best friend cannot put their money into the trust on behalf of the beneficiary. At the death of the beneficiary, similar to a pooled trust, the state Medicaid agency is reimbursed with the remaining assets in the trust. And so there's no control over what happens with what might be left in the trust upon the person's death. The third party special needs trust is similar, except that it is funded by someone other than the beneficiary. It could be through an inheritance, a life insurance policy, a gift, and the funds never technically belonged to the beneficiary. Upon death, funds in the trust can be passed to other relatives, or they can be given to charity. That will be dictated in the trust document. There's no requirement to reimburse the Medicaid agency because the funds never belonged to the beneficiary in the first place. In the case of a third-party trust, as well as a first-party trust, a trustee who is determined by whoever sets up the trust. So let's say you set up a trust for your son or daughter. You would decide who the trustee is, and that's an important decision because the trustee is the person who, over the life of the beneficiary, will manage the trust and make the distributions. You can also be the trustee as the parent or guardian. It's an important role that requires knowledge of public benefits and those income and asset limits, and also, most importantly, a commitment to and a real understanding of the beneficiary's well-being. You can have family members serve as the trustee, or you can also designate a bank or even a trust company to be the trustee. That most likely is going to come with some fees, and those fees might be significant. So that's important to find out before you go that route. And first party and third party special needs trusts really need to be set up with the help of an attorney because you want to make sure that you do it right and that you're following all the rules, and importantly, that you have a very clear understanding how to manage the trust once it's set up. A Miller Trust is not considered a special needs trust. It's considered a qualified income trust. And the Miller Trust is real specific to helping to qualify for Medicaid's help with paying for long-term care, especially if the person's regular kind of monthly income exceeds Medicaid's limit. So with a Miller Trust, any income that is in excess of the Medicaid limit is put into the trust, and the funds are controlled by a trustee, as well as with the first and third party trusts. That trustee can be anyone but the beneficiary. Miller trusts are a little more flexibility. They're flexible. There's no age restriction and no disability requirement. So technically, someone who's not disabled could set up a Miller trust. And one of the key distinctions with the Miller Trust is that the funds can only be used for very specific purposes, long-term care expenses or medical expenses. Similar to the first party and the pooled trusts, upon death, the remaining funds in the trust are returned to the state of Wyoming. And not all states allow Miller trusts. Wyoming does, but the rules vary by state. Another important way to protect assets and income and continue to qualify for benefits, and Jesse's going to cover that, and that is ABLE accounts.
Yes. And I'll start by saying that we've found ABLE accounts to be pretty significant in really benefiting our clients here. So I just wanted to lead with that. But essentially, a federal law was put into place in 2014 under the Achieving a Better Life Act, which established savings accounts that allowed people with disabilities to put aside savings while still qualifying for public benefits like SSI. If the beneficiary is under 18 or unable to open an account on their own, an authorized legal representative can open the account. And contributions can come from the individual, from their employer, their family, or their friends. And you can contribute up to $20,000 a year. And it's even $15,560 additional to that if they're employed. SSI is not affected as long as the account balance stays below $100,000. There is a need to keep documentation of what you spend that money on, just in case the IRS needs it. And there are some spending restrictions. So they what you're able to spend it on essentially is qualified disability expenses, such as education costs, food, housing, medical and wellness expenses, funeral expenses. But you cannot use it to make gifts to charity, and it does limit spending for entertainment purposes as well.
Thank you, Jesse. I'll add one quick note that for Wyoming, the program that provides ABLE accounts is called YABLE, WYABLE.com. Again, that link will be on the resources page, and that's where you would go to start the process of setting up an ABLE account. All right. We're going to switch gears a little bit and talk about guardianship and conservatorship. And these are two of the legal steps that are important to consider taking when the person with the disability is approaching the age of 18. So when they're moving from the status of being a minor to being an adult. So guardianship and conservatorships are legal relationships between the guardian or the conservator and what they call the ward, and that's the person with the disability. Guardianships and conservatorships are both created by court order, and they are very important to be put in the place with the guidance of attorney. This is a formal court procedure when appointing a guardian or a conservator, and this is because when a child turns 18, they can start making decisions for themselves, and parents lose access to medical and school records and are no longer part of the medical and therapeutic relationships that they were probably very active in up until the age of 18. So depending on the needs of the young adult, they can be an important piece to put into place. They're taken very seriously by the court because they both involve removing significant rights and freedoms. Guardians and conservators, as you can see on the slide, are preferably people who are very involved in the ward's life and who deeply understand their needs. They can be parents or siblings, other relatives, godparents, friends. They can also be professionals or nonprofit agencies. Again, if you are going that route, I would make sure that you have a very good understanding of any fees that might be involved if you use an outside person to be the guardian or conservator. You can also have two people that serve together as guardians or conservators, and they make decisions jointly. Guardianship may be considered if the adult has been found to be incompetent. It's an unfortunate term. I'm not crazy about it, but it is the term that's used in the Wyoming state statute, and it's a very specific definition. So I'm going to go with their term. Incompetence, as defined in Wyoming state law, means that the person is unable, while unassisted, to properly manage and take care of him or herself or his or her property as a result of the medical conditions of advanced age, physical disability, disease, the use of alcohol or controlled substances, mental illness, mental deficiency, or intellectual disability. And whether or not a person meets that standard of incompetence is decided by the court. The guardian is the person that is approved by the court to take care of the adult who needs assistance due to incompetence. And I'll back up. I missed one of the bullets. Limited or as expansive as they need to be in order to meet the person's needs. It's important that when setting up a guardianship, that it's done in the least restrictive manner possible. And that's something that can be thought through with the guidance of your attorney. And it's something that the court's going to want to see as well when you come to them with a proposal of guardianship. The guardian, him or herself, is also approved by the court, and they do things like ensuring appropriate living arrangements, facilitating the ward's education, vocational or social activities, really caring for the adult who needs assistance. They are authorized to give permission for or withhold consent for medical procedures. And the guardian is also authorized to spend funds that the conservator gives over for the ward's benefit. Guardians are required to file reports with the court every 6 months to provide an update on the ward. And I can speak from personal experience that if you don't file those reports, you will hear from the judge. So that is a very important thing to stay on top of. It can be a big responsibility. So it's an important thing to consider carefully at the time when the person is turning 18. Okay, we'll go to the next slide and talk a little bit more about conservatorship. The definition of incompetence is the same as guardianship, so I won't read that again. The conservator can be the same person as the guardian, and conservatorship is intended to provide protection of the property of adults who are not able to make or communicate responsible decisions regarding the management of their property. This might include entering into contracts, buying or selling property, conducting transactions. If it is outlined that way in the conservatorship order, the conservatorship documents, the conservator is authorized to do all of those things. This is also a fairly extensive court process, and it's very similar to the guardianship process. Conservatorships, again, should be tailored so that they're set up in the least restrictive manner, and conservators are required to file annual reports in the court with a full accounting of the ward's assets. When you set up a guardianship or conservatorship, if your attorney who helps you doesn't provide kind of templates for these reports, I would ask them for that. I imagine you can also find them online, but these reports, in my personal experience, don't take a lot of time to do, but you need to make sure that they happen or you're violating the order. So that is where we'll stop with the information dump. A couple of things I wanted to point out is that, as I mentioned, you should probably get started working on guardianship or conservatorship at least 6 months before the individual's 18th birthday. I want to emphasize again that it's important to work with an attorney to set up pretty much everything that we have just described in the last hour or so, with the exception of the pooled trust. You don't need an attorney to help you set up a pooled trust or join a pooled trust. Of course, hiring an attorney can be very costly. There are some local and statewide resources that can help. Teton County Access to Justice is a Jackson-based nonprofit that offers clinics, like free information sessions on the first and third Thursdays of every month from 2 to 4 p.m. at the Teton County Library's main branch over on Virginian. And essentially they, from what I understand, they set up a table and you can show up during that time. It's kind of like office hours, and get some information. You won't get legal advice during that time, but they can provide information and might be able to answer some questions. Teton County Access to Justice is limited to civil law matters. Everything we've discussed tonight is considered civil law. They do not provide legal assistance with criminal law. And they have an income eligibility, which is under 200% of federal poverty guidelines, and that individual assets cannot exceed $5,000. Their website will be in the resources page that we send out, and they have an online application, and they do end up doing income verification. So they'll help you work through that process. The Wyoming State Bar Modest Means Program is another resource. I think they work similarly to Teton County Access to Justice. Their income eligibility might be a little less restrictive. I believe it's 200 to 300% of federal poverty guidelines. But those are the primary resources that are available. And we'll also provide a link to a few other resources that are provided by the Wyoming State Bar. And that concludes the information that we wanted to share. And our last thing on our agenda is to see what questions you have.
This is Colleen. I know
Hi.
most of you. Unfortunately, fortunately, we're actually in the middle of dealing with trying to set up trusts for both Nikki, who's online, and our son Christopher, who's also special needs. Nikki's is totally different situation. She's on all the benefits, etc. My son is high functioning special needs. He works full time. He's been on his job for almost 18 years. He gets free insurance, absolutely no benefits. He's actually paying back $40,000 to Social Security. That's been going on for many, many, many years. He got roped into a bad mess, even dealt with an attorney, or excuse me, a judge, regarding his case. But all of his concerns, I'm not sure where he falls into some of this because he doesn't have any. He's almost 35, by the way.
Mm-hmm.
And what else was I going to say? The other thing that concerns me a lot on him is like he was on the waiver a long time ago. And then because of working full time, choosing to work full time, and he can, losing all that, he doesn't qualify for anything. And what Jesse was talking about, CES does things also of working with the client individually on things. And the only thing he really needs, technically, is helping him with his hygiene and cooking, cleaning, and forget the rest of it. He doesn't need those things, but he desperately, desperately needs help with that. So I'm not sure where he falls in the trusts, and I'm also concerned a lot about what happens to him for his future because we're not young anymore, and when we're gone, I'm not sure what's going to happen to him.
Mm-hmm.
So I don't know if anybody knows, because I know that everybody that's online that I know, all of our situations are different, but I'm not sure anybody falls in the category of where he is. And we are his legal guardians, parents are as well.
So you've set that up. You set up a guardianship
Yeah,
arrangement.
before he was 18, and he's almost 35, so he's had that for a long time.
Mm-hmm. Heather, do you have any insights into? It sounds like, Colleen, what you're describing is that he falls into this kind of gap where because
Correct.
he can and wants to work full time, and the nature of his disability, makes that as a possibility for him, and that's the good news, right?
Right.
That he is not he's not disabled enough and not of such limited income that he qualifies for any help, but he needs some help.
And he's cognitive delayed. So like when we're gone, I've been picking my brain forever. What the heck are we going to do with him? I don't know what to do. He can't handle any of that stuff. And I'm not sure what route to go. There's no family or friend that I know of that's the right person for him. So it involves the financial and the trusts and, everything in between. Guardianship, who pays the bills, who does this, who does that. I don't know what to do with him.
Mm-hmm.
Yeah, and typically what I have seen with other participants, they end up paying out of pocket just at those services that you're talking about, whether that's like a rep. Well, he doesn't have a rep pay because he doesn't receive Social Security, you said anymore, correct?
Correct. None of that at all. The only
Yeah,
thing
so
he's on
like,
is the ABLE Act.
okay. Yeah, so I mean, really, I think um, paying out of pocket for, just financial support, and CES does offer that. There are a couple people who are not on the waiver, but they work full time and they do need help. And so
So
CES, they'll pay out of pocket monthly, and so we'll maybe go into their apartment and then they'll come
can
in once a week.
that be paid, Heather, out of his ABLE Act?
Yeah, I
Oh,
believe so.
okay.
Yeah. That's definitely that definitely falls under, what ABLE allows you to use that money for.
Cool. I didn't even know that. I had no idea.
Yeah, so I mean, like typically there's a few other clients in the community that will come in once a week for, working on their bills and just making like a check and balance. CES is a check and balance essentially, and then coming into their apartment, and they just pay out of pocket because if he's working full time and he has that income and then he has that savings. Um, He also could, CES's rates are definitely, and Jesse can speak to this more, are the most reasonable. He could, also find someone in the community to pay out of pocket as well. But I think the rates with CES are definitely the most um, just reasonable, like it, affordable. Um,
Okay. That's
so yeah.
wonderful.
Yeah, and just as um, to loop everyone in, CES is not immune to staffing issues, like everywhere else in Teton County, it seems.
Yeah.
I currently have a really pretty robust staff, and I think they're doing great things.
Is there a way of knowing the right and the wrong for which kind of trust to take for someone like that? Parents, a lot of us have our older parents that are listening online as to making the decision. So you're gone, we pass away, and they're by themselves, hopefully have some guardian in at that time as to, they need that money to survive. But it sounds like those trusts are all over the board.
I think so we're getting a little out of my wheelhouse, but I do believe that, and I'm glad that you're already working with an attorney. I think you said you have a meeting tomorrow. I
Correct.
think there are ways to weave the trust in with your will. And so I would talk to them about that as kind of an overall estate planning um, process.
Okay.
And the differences between the trusts have a lot to do with where the money is coming from. For example, with the first and third party, the main difference is that the money, with the case of a first party trust, was already belonged to the beneficiary. And in the case of a third party trust, it came from somebody else, including like a life insurance policy. So I would talk through that with your attorney, and they should be able to guide you through that. Important to remember that with a first party trust, when he passes away, that money will go back to the state to repay. I don't know how it works if he's not on the waiver, but it's not necessarily going to be passed along to any other family member or somebody else that you all choose, a charity or something like that. But with a third party trust, those are all options.
Okay. Thank you. Sorry it took up everybody's time.
It was
Thanks
a
for all
great
your
question.
help.
Carrie asked a question if, do you know if you have to get both a guardianship and a conservatorship? And I believe you do not. That's again, I don't want to get into like legal advice, but I think they can be kind of done together in one order if you want to set both up. but I don't believe you have to. The conservatorship, from my understanding, deals more with money and finances and contracts and entering into financial arrangements. And a guardianship is kind of every other aspect of life. Heather, did you want to jump in?
Yeah, we did. We used to have I have a lot of participants who, have one or the other. So you don't need to have both.
Great. And Anna put a kind of a pro tip that you can put paychecks directly into ABLE accounts in order to avoid concerns of accidentally going over monthly limits. And maybe that's even a direct deposit type of setup. I'm not sure. I added that piece of it. And I believe, Jesse, correct me if I'm wrong, that ABLE accounts make it pretty easy to withdraw the money, to um, even have a debit card, which can be problematic in its own right, but they essentially function a lot like a bank account.
Yeah, it's almost scary, the process to get that money. Um,
Because it's so
and
easy.
yes, it's so easy. And, I think specifically for some clients I've worked with, they don't understand those qualified purchases. And I would hate, for them to end up in trouble for that. Yeah, and then another thing to note about ABLE accounts, which might not be applicable to everybody, but there is a lifetime contribution cap. So if you start contributing for a child when they are young, just something to be wary of. I do think it's something like $500,000, but just wanted to throw that out there as well.
I have a question in regards to that.
Yes.
Do you know if a car can be purchased from the ABLE Act?
I've had a client purchase a vehicle with their ABLE account.
You have?
I have.
Okay.
I was just reading last night too, and it says you absolutely can do that.
Can or can't?
Can.
Can, okay.
Hi, Cindy. Thanks so much for putting this together. This is Anna.
Hi.
And we've done conservatorship and guardianship. And I actually did just get online forms. I did not use a lawyer for that. So Anne Sutton and her team were quite helpful. And I just used that they're on the Wyoming website, government website. So if you can't find them, I'd be happy to dig in and find those again.
That's great. And I appreciate you saying you did it, as I was calling it, DIY, and it worked out great.
Yeah, I mean, you're right. It's very important to do it timely. And there is definitely some really pertinent information, particularly in the conservatorship side. Guardianship is more of a looser, I would say, but you need to obviously put in the various pieces that's in the form. But it's doable. I worked through it and it was doable. Yeah. Unlike the trust, which I agree, which is much more legally binding.
Has anybody in the group, parents or CES who's got clients that have been long-term guardianship? So like Christopher's almost 35. We got it before he was 18. And from what I understand, I can't remember what someone told me, but they mentioned what Christopher has is it's super old. So the forms that with the attorney that wrote it up, there's never been an issue with someone saying we're not legal, but I understand it's changed. Is there such a thing as an outdated guardianship? Anyone know about that?
I don't know for sure. My hunch is that, well, as if the person who is, I'm putting in quotes, the ward, if their needs or their situation changes and therefore kind of the terms of the guardianship need to be updated, that would probably be good to do and good to look at from time to time. And I'm assuming that that is some kind of amendment that you do through the court. And then my other thought was, I would hope, and you guys can weigh in, that that the judge who oversees guardianships would catch if something was, so outdated that it was kind of harmful to the person who was subject to the guardianship. But I'd love to hear what anyone else has to say.
You also mentioned something about, what was the word? I wrote it down, but I can't remember what you said about every 6 months or something about it being checked.
You have to submit a report.
Well, guess what? We've had this since before he's 18. I've never, ever, ever been told to do that. Never, ever have done anything with that guardianship, or have I ever been contacted by anyone.
So we have a few other families who are in the same boat as you. They've had the guardianship in place for a really, really long time too, and they didn't do any paperwork. And recently we've had, as a case manager, the state of Wyoming has had us, Medicaid specifically has had us upload documents that, I used to upload just the guardianship forms, and even if they were done back in whatever, 19, you know, whatever, 80 something.
Right.
Now they have us update the form, the every 6 month form that shows that I don't know what they call it. It's like a check-in basically. But I think that if you just go into, I believe it was like the clerk's office, they will help you with that, and you can start doing those every 6 months, and they will make sure you're on the list so that you're getting it in the mail as a reminder, because you're not going to be in trouble, and the guardianship is not going to, it's not going to lapse or anything. It's just, you should start doing those, and just so that, you have documentation that it's current. But again, it's not going to, discontinue your guardianship. It's just, it'll just show that it's current when you do those every 6 months kind of check-ins.
I thought that seemed a little bit too easy. It's like,
Yeah, it's
I've
very
had
weird. I
those
don't.
forever.
Yeah,
And
it's interesting that they weren't checking in on those. I don't know what happened, but we had the same thing where I went to go upload something and they're like, "This is the original paperwork. Like, we need to know that it's current." And so they were like, and so we went into the office, the clerk's office, and they were like, "Yeah, we have a process for that, and we just started getting on top of it." And I would say that was like 2 years ago now, maybe a year and a half, but now they're sending out these reminders and the paperwork. They're sending out the form. It's a pretty simple form though. But I would say if you just go into that office, they can guide you, and then they can get you on a mailing list so that you're getting that reminder with the paperwork every 6 months.
Carrie and Anna, do either one of you have an old guardianship from way back when? And have you ever been contacted about that?
Yeah, I had a guardianship when Zach was before he was 18, and I hadn't filed a report, and I got a letter from the judge,
Oh, you
and
did?
stating I needed to start filling it out.
How long ago did you receive that?
Oh, a couple of years ago.
Okay. Okay.
I have,
Thank you.
I mean, Marcus has been 7 years now, and they must have. We've done it once a year, conservatorship, just normally after you've done his taxes, and then guardianship twice a year. And we have had letters from judges, but they've been all over the place. I mean, we've had multiple judges here, and literally letters saying we've never had so much written about someone, to letters saying you need to get your report in. So clearly they have different types of people completing it, and some are more. Yeah, I think they are less strict with parents, to be honest. But anyway, it seems to have been fine, and I'm sure, as you said, Anne Sutton is great. She's been incredibly helpful, and I would recommend chatting to her or her staff.
Great. Did you say the Sutton employee?
Anne Sutton.
Yeah. Okay. Great.
it. Yeah. On behalf of the judges.
Okay, thank you.
Well, I think we have probably answered all the questions that were posed, and this has been great conversation. Thanks, everyone.